I had a viewer ask me to describe a collection action based upon an account stated allegation in a debt buyer complaint. That's a common collection claim in lawsuits. What is account stated and how do you defend such a claim? Well, that's the topic of this video. Hello again, everyone. I'm attorney Robert Flessas. Account stated is commonly used in debt buyer lawsuits filed against consumers all over the country to collect on debt that they purchased. But first, if you like my videos and find them helpful, please consider subscribing to my channel. Well, we've talked about the other allegations advanced by debt buyer attorneys in a collection lawsuit and how to defend yourself against them. The one we haven't talked about is an account stated claim. An account stated claim means that there's an agreement, either in writing or based upon prior dealings between a creditor and consumer without a written agreement. The claim basically states that the money is due from the consumer based upon a promise made by the consumer to pay the debt, and that they agreed to the amount of the debt and owing the debt just by the consumer's silence when the demand was made for payment. Many states in the country treat this claim differently, so you have to look at your local contract law and consumer protection websites. If that's the claim that a debt buyer is making, then generally they have to prove the following. There has to be a pre-existing debt or payment obligation. And second, the consumer agreed to the amount they owed by failing to object to the amount within a reasonable time. So can an account stated be used in a consumer debt collection lawsuit? Well, let's start here. The account stated allegation is really being used as evidence. They want to get a judgment against you without providing any proof. Debt buyers are using this claim to get around having to produce the original contract as evidence to prove their case, among other things they must prove. And they're probably using this tactic because they don't have the contract. That's why you see debt buyer lawsuits only using a one-page statement attached to their lawsuit, because that's all they got. If you've watched my other debt buyer videos, I talked about requesting documents from the debt buyer's attorney to see if they even have those documents. In most cases, they don't. The link to that document is below, and you can download it for a very small fee. That document, when submitted to the debt buyer's attorney, asks them to produce documents to prove their case. And if they can't produce those documents, then you have to move the court to dismiss your case. Now let's get to the defenses you may want to use against an account stated claim. One of the defenses is that this theory does not support modern contract law. A little history for you. Contract law has evolved over hundreds of years and billions of transactions between two parties. The law is not static. It's refined according to different transactions over time and the different parties over time. That's also why consumer protection laws were enacted, to protect consumers. Generally, in modern contract law, silence does not mean acceptance when it comes to consumers who owe debt. There needs to be a written agreement and acceptance of the credit and the promise to repay. Consumers must plead to this defense to a judge. But remember, some courts won't accept this defense. What a debt buyer is trying to tell a judge is, if you didn't object to a demand for a balance due, then you, the consumer, by doing nothing, means that you agreed to the debt. And they're using this claim against an unsophisticated consumer to claim that this debt is enforceable. The debt buyer is shifting the burden of proof to you. In other words, you prove that you don't owe the debt. Well, that's not fair. They sued you. A second defense could be that an account stated claim is against public policy. You argue that it violates consumer protection laws in your state. That's a big one. And that's why you should check your local consumer protection laws. The third defense could be that account stated violates modern contract law. This defense states that silence is only considered your assent if the account stated claim is between two merchants. Do you understand that? You're not a merchant. In other words, this would apply in transactions between commercial parties. You're not a commercial party to the transaction. By arguing against account stated, then you're forcing the debt buyer's attorney to support their allegation by citing the specific law that would support their legal theory. Remember, challenging a debt buyer's lawsuit is the first line of defense. Don't ignore it. Like I've said many times in my other videos, you make the debt buyer's attorney work to prove their case. Fight. Don't let them walk all over you. By challenging them, you're either going to get the case dismissed or substantially reduce the amount they're asking the court in order to settle your case. Well, I hope this helped. I'm attorney Robert Flessas. Thanks for watching. Think about subscribing, and we'll see you in the next video.